Your take on this one now that we've seen the evidence in this case? What do you think is going to take place in terms of, do you think the state was able to prove their case beyond a reasonable doubt?
Here's what I think. I think law school professors from around the country are rubbing their hands and saying we have a perfect case to use in teaching new law students about the battered abuse wife syndrome defense, because this case has everything. In law school, they don't test you on things that are slam dunks. You're expected to know the elements before the first day of class. They test you on cases that could go either way. So to answer your question, Ted, I think the murder one charge was appropriate at the time it was given. If you're an investigative agency, you're not there to try exotic defenses such as battered spouse syndrome. If you take that out of the equation, what do you have? You have a trained law enforcement officer wearing a vest, shooting another person 9 times while they lay on the couch, because that's what the state knew before, when they made these charges, because they had the examiner, they looked at the forensic evidence, they looked at the pillow, and that is what they had, right? When you inject that in, by the way, she had some zealous advocacy by her defense attorneys. I mean, her defense attorneys really want to acquit their client. When you add that in there, it makes it very difficult, right? I think in their closing arguments, the prosecution missed the lead, which is, hey, a lot of us know somebody who's kind of a bad person, but if you woke up one day and you found out that they were shot 9 times while they were laying on the couch, you would assume someone's going to go to jail for that, right? They kind of missed that, and it was a very disrupted type of closing statement. But other than that, I think this is a tough one, Ted. It could go either way because the facts go against her, but she goes in her favor. She was an amazing witness in her own defense.